Okay, so this is an overview of Chapter 7 bankruptcy as well as different alternatives to Chapter 7 bankruptcy. There are basically three options when you're considering bankruptcy. First is to do nothing, and actually in some cases, believe it or not, doing nothing may be the best option for you. The second is to work out some sort of payment plan or a settlement with your creditors. And then finally, the third option is bankruptcy. All right, now let's talk a little bit more about doing nothing. If you do nothing, a creditor may sue you or may let the statute of limitations pass. So let me tell you a little bit about what the statute of limitations is. Basically, a creditor in California has 4 years from the date of default, and the date of default is usually the date of your last payment. They have 4 years to sue you. And if they don't, then that deadline passes and they can no longer sue you. So that deadline, that 4-year deadline, is called a statute of limitations. Even if the statute of limitation passes, that debt can still be on your credit for a total of 7 years. Now, if a creditor does decide to sue you, they can get a judgment. With a judgment, there are essentially 3 things that a creditor can do that they can't normally do or they can't do without a judgment. The first thing is a wage garnishment. They can garnish your wages up to 25% pre-tax. The second thing is they can levy your bank account, and a levy is where they find your bank account, and they actually pull money out of your bank account, and they can keep doing that until the full amount of the debt has been paid off. The third one mainly applies to people who own real estate. What it is a lien. They can put a lien on your property. So essentially what that means is if you were to try to sell your property down the line, you would have to pay them off or settle with them before they would release that lien and you could sell your house. Now, a certain category of people are what we call judgment proof. Judgment proof means that even if a creditor sues you, they can't recover any money from you. There are certain classes of people, so people that are getting government assistance, for example, unemployment, Social Security, SSDI, any kind of government disability, those in most cases cannot be garnished by creditors. So, especially, for example, a retired person, they may be judgment proof, where the creditor can sue them, but they're not going to be able to get any money. There's no wages to garnish. They can't put a levy on the bank account if you can prove that the money that's in the bank account comes from government funds, for example, from Social Security. And if they don't own property, a lien isn't going to have any effect. So a retired person is a good example of someone who is judgment-proof, especially if they're not anticipating working again. Now, some of you may be judgment-proof because you're not working right now. You may be collecting unemployment. However, in the future, if you get a job, you may no longer be judgment-proof. If you have a change of income, even if you're judgment-proof right now, you may be susceptible to a wage garnishment or other post-judgment remedies after you start working again. And in that situation, you might need to reconsider your options. If you've decided not to do anything for the moment because you're judgment-proof, later on you may need to look at a payment plan or possibly bankruptcy. Probably the most common complaint that people have is that they get a lot of phone calls and letters from creditors. You can actually get the creditors to stop sending these letters by sending them what's called a cease and desist letter. A cease and desist letter is also called a no contact letter. If you send them this letter, by law, they have to stop contacting you. They have to stop calling you. They have to stop sending you letters. Now, they could still sue you, but they have to stop all of the collection activities. All right, let's talk a little bit about if you get a judgment against you. A lot of you are concerned because creditors have threatened to sue you or they actually have sued you, you've been served with papers. Even if a creditor gets a judgment against you, in most cases you can still discharge or eliminate that debt in bankruptcy. All right, let's talk about the second option, which is a payment plan or a settlement. For some of you, if you have income coming in or you have a chunk of money, you may be able to arrange some sort of a settlement with a creditor. And a settlement essentially is where you negotiate with the creditor to pay off a certain amount of debt for less than what you owe. So for example, if you owe $10,000 in credit card debt, you may be able to settle for less than $10,000. You could be 50 cents on the dollar, 25 cents on the dollar. It's whatever you are able to work out with the creditor. Now, one thing is that you can actually do this by yourself. There are companies out there that will say, well, give us money and we'll contact the creditors and we'll work out some sort of settlement plan. This is nothing that you can't do on your own. So I would recommend trying to work out some sort of settlement with some of your creditors. If you can come up with a lump sum payment, sometimes even a creditor will accept installment payments, maybe a few installments. I've seen up to a year of installments where you're paying off less than what you owe. There's also a number of nonprofit agencies that you can arrange to pay back credit cards or other types of debt over a period of time. What happens is they will lower your interest rate in many cases, and you make one payment to this nonprofit agency, and then they distribute the money to the creditors. The problem with both of these is that they're all voluntary. So the credit card companies or the other creditors are under no obligation to accept a payment plan or even a settlement. But one of the pros of this is that you do get to avoid having a bankruptcy on your record. And a bankruptcy is on your record for 10 years. Now, let me just say a little bit about that. A bankruptcy is on your credit report for 10 years. If you have debts discharged in bankruptcy, it'll say discharge in bankruptcy under the name of the debt. However, it may not affect your credit for that long. In fact, many people can recover very quickly after bankruptcy. Within maybe a couple years, you can qualify for a car loan at some of the same rates that you've been offered before bankruptcy. Within maybe 3 to 4 years, you can sometimes qualify for a mortgage at non-bankruptcy rates. All right, so now let's talk about the final option that we're going to discuss today, which is bankruptcy. And I want to discuss the two different types of bankruptcy that are most common to consumers. Those are Chapter 7 and Chapter 13. You probably have heard these terms. I'm just going to give an overview of the differences between Chapter 7 and Chapter 13. Chapter 7 is what's called straight bankruptcy or liquidation bankruptcy. And in Chapter 7 bankruptcy, you discharge or eliminate most or all of your unsecured debt. Now let me just distinguish between unsecured and secured debt. Unsecured debt is debt there's no collateral against it. So credit cards, personal loans, medical bills, there's no collateral against those. So those are unsecured debt. Secured debt, a couple of good examples of secured debt are home loans and car loans. With a home loan, the loan is secured against the house. So if you stop paying on the house, the lender can foreclose on the house and recover the house. With a car loan, if you stop paying, the lender can repossess the car, sell the car, and use the proceeds to pay toward what you owe. In Chapter 7 bankruptcy, you're going to be able to eliminate most or all of your unsecured debt. You also may be able to protect most, or in some cases, in fact, in many cases, all of your personal property. And a bankruptcy case in Chapter 7 lasts about 4 to 6 months, depending on how long it takes for you to fill out the forms. Once you file, it's pretty standardized how long it takes. Let me talk about Chapter 13. That's called the wage earner's bankruptcy. Chapter 13, there's a few instances where people may choose Chapter 13 over Chapter 7. Chapter 13, you can also discharge all or a portion of your unsecured debt. But in Chapter 13, you're actually paying back your creditors some or all of what you owe them. And it can be a 3-year plan or a 5-year plan. So you're paying them back a portion of what you owe them, or in some cases, all of what you owe them, but it gives you extended amount of time to repay them. One of the most common reasons people do Chapter 13 is because they make too much money to do a Chapter 7. In order to qualify for Chapter 7 in most cases, you have to make below the state median income. If you make above that, if you make too much money, then the court feels that you have some ability to pay back some of your debts, so they'll make you do a Chapter 13. And there are also other reasons some people may choose to do a Chapter 13. People who are behind in secured payments, like on a car loan or a home loan, if you're behind on payments and you need to catch up, Chapter 13 will let you do that while under the protection of the bankruptcy court. So while you're in a Chapter 13, as long as you're making the payments and you're catching up, they can't foreclose on your house or they can't repossess your car. All right, let me discuss some of the pros and the cons of bankruptcy. Some of the pros, now as we discussed, you're able to discharge most or all of your unsecured debt. You get a fresh start, and a Chapter 7 bankruptcy, actually both 7 and 13, the minute you file bankruptcy, it stops collection activity, garnishment, and bank levies. Now some of the cons, as I said before, bankruptcy will be on your record for 10 years. It can, in some cases, negatively impact your credit rating, although a lot of that is dependent on where your credit score is to start with. And some creditors may refuse to do business with someone who has a bankruptcy on the record. For example, some landlords will refuse to rent to someone who has a bankruptcy on the record, or in some cases, they may just require more of a security deposit. As I said, today, we're only going to be covering Chapter 7 bankruptcy for people who do not own any real property. Because in that situation, if you need to do a Chapter 13 or if you have real property, we strongly recommend that you seek the advice of an attorney. All right, there are certain types of debts that are not dischargeable, meaning you cannot eliminate them in Chapter 7 bankruptcy. So some of those debts are taxes with certain time limit exceptions. So some older income taxes you may be able to eliminate in Chapter 7 bankruptcy. Domestic support obligations, so child support payments, any alimony, things like that, any back payments, those cannot be eliminated in bankruptcy. Student loans, by and large, you cannot eliminate in bankruptcy. There's a very narrow exception for undue hardship, but it's very difficult to prove an undue hardship as far as eliminating student loans in bankruptcy. Traffic tickets and government fines, also not dischargeable in bankruptcy. Any alcohol-related accident judgments, any judgments related to that, not dischargeable. A judgment for willful or malicious conduct that results in serious physical injury or death, not dischargeable. And any unlisted debts also may not be dischargeable. Now, one of the biggest concerns that people have is, am I going to have to give up stuff? Am I going to have to turn over my property in the bankruptcy? Well, fortunately, in most cases, the vast majority of Chapter 7 cases, you can keep most or probably all of what you own, assuming you don't have a large number of assets. In bankruptcy, there are what are called exemptions, and exemptions are essentially protections. So anything you own, you would want to have a corresponding exemption to protect it in the bankruptcy so you don't have to turn it over. There are exemptions for household goods and furnishings. There are exemptions for jewelry, pension plans and retirement accounts, and there's a number of other exemptions. And then for anything else that's already not covered by an exemption, there's what's called the wildcard exemption. The wildcard exemption applies if you don't own any real property, and you can protect up to about $23,000, a little over $23,000 of assets that aren't already protected by another exemption. So for example, if you have cash in the bank, cash on hand, stocks, bonds, if you have a car that has a high value, you can protect it as long as the total of everything isn't more than $23,000. Now, if you have a lot of property valued at over $23,000, you might need to surrender some of it, or you might consider doing a Chapter 13 bankruptcy. In fact, that's another reason why sometimes people will consider Chapter 13 is if they have a lot of valuable assets that they want to keep that otherwise in a Chapter 7 they might have to turn over. Now, there's some determinations to go through to see if you actually qualify for Chapter 7 bankruptcy. The first is, have you filed for bankruptcy in the past 8 years? You can only get one Chapter 7 discharge every 8 years. So if you have a discharge that's more recent than that, then you may not be able to do Chapter 7. Again, you might want to consider Chapter 13, which has a shorter time between bankruptcies. Also, have you lived in California for the last 2 years? And have you lived at your current address for the past 180 days? These are some venue requirements. You have to have lived in our district. Our district is called the Central District of California. It covers most of Southern California except for San Diego and Imperial counties. It's a very large district, the largest district in the country. So as long as you've lived somewhere in Southern California for the last 2 years, you should be fine. If not, you might need to file in a different district, or if you've lived in another state, you might have to use that other state's exemptions. There's also what's called a means test. A means test determines your eligibility for Chapter 7 bankruptcy. And in the means test, it compares your income to the median household income of each state. So in this example, it would be the median income of California. If your income is below the median income, then you qualify for Chapter 7 bankruptcy. Most everyone here should qualify under the means test. Just to give you a little sample, currently for a household of one person, the median income is just under $48,000. For two people, it's about $62,000. For 3 people, it's about $67,000, $68,000, and then it goes up from there. But if your income is below that for your household size, then you should qualify for Chapter 7 bankruptcy in most cases. There's also a credit counseling course you have to do. Now, some of you may have already done this. We have a list of providers in the packet. There's one that's actually costs only $5. This is an online course or an over-the-phone course that you do. It takes an hour to 2. At the end of it, you'll be issued a certificate, which you have to include with your bankruptcy paperwork when you file it with the court. So you need to do that credit counseling class. You also need copies of your pay stubs. You'll need to gather copies of your pay stubs for the last 6 months. You're actually going to be using those in determining your eligibility under the means test that I talked about. They're going to look at your last 6 months of income. You also need to have the last 60 days of pay stubs that you're actually going to include with the petition. So you need 6 months in preparing all the paperwork, and you're actually going to turn in 60 days worth of pay stubs with your bankruptcy paperwork. You'll also want to keep all copies of bills, judgments, collection activity. So those bills that you're getting from your credit cards or collection agency, debt collectors, don't throw them away. You're going to need that information from those bills. You need to know how much you owe and the name of the creditor, so you can include that in your paperwork. That's very important in bankruptcy. It's important to include everyone you owe money to, even friends, family members, personal loans. You have to include everything. You're also going to want a copy of your credit report. We're going to show you how to get a free copy of your credit report from each of the 3 agencies. You're going to need that credit report because that's going to give you a good list of most of the people you owe money to. Now, keep in mind that not everyone that you owe money to is going to be listed in your credit report. For example, if you have a loan with a family member, that's probably not going to be listed in your credit report because your family member isn't reporting to TRW or Equifax, one of those agencies. You're also going to need copies of your taxes for the last 2 years. You're going to need that in preparing part of the bankruptcy. And you're also going to need to know how much you've earned this year. You're also going to need to provide a copy of your most recently filed taxes to the bankruptcy trustee. And let me talk a little bit about the bankruptcy trustee. In each Chapter 7 bankruptcy case, there's a trustee assigned. And a trustee is essentially an administrator who oversees all of your assets and your debts. They oversee your case until you receive the discharge in your case. And these are people who are, in most cases, lawyers or accountants, and they do the trustee work as a side job. So these aren't full-time trustees, they do this on the side. And you'll have actually one in-person meeting with the trustee, which I'll talk about in a little bit. But you need to provide your most recently filed taxes to the bankruptcy trustee before your meeting with the trustee. You'll also need to go over your monthly income and expenses. You're going to need to create a budget. See how much you're actually spending and how much you're actually taking in. You'll also need any information on co-debtors. These are people, for example, if you have a co-signer on a car loan, you need that information because that needs to be included in the bankruptcy paperwork. Information about any pending lawsuits. This is any lawsuits where you're suing someone or somebody else is suing you. You're going to need to include that information in the bankruptcy. Any potential lawsuits that you have against someone, you'll need that information. You'll need to have a valid Social Security number and Social Security card. You're going to have your identification, a government-issued photo ID, and your Social Security card at the meeting with the trustee for verification purposes. So if you don't have your Social Security card or you can't find it, you can contact the Social Security Administration and they will issue a replacement card at no cost. Also, any 401k loans, if any of you have borrowed from your 401k or other retirement accounts, you need to have that information. Any information on student loans. Even though in most cases student loans are not dischargeable, you're still going to want to include that information because you have to include all of your debts in the bankruptcy. Any information on parking tickets, moving violations, any government fines like that, you want that information again. Even though that's not dischargeable, you still want to include that information in your bankruptcy petition. All right, now, where are you going to file your bankruptcy petition? Well, it's going to depend on where you live. So what you should do is you're going to go to this website, www.cacb.uscourts.gov. You're going to click on location and do a zip code search. You're going to put your zip code in, and it'll tell you where you're going to file your bankruptcy paperwork. And in our district, which again is the Central District of California, there are 5 bankruptcy court locations. There's downtown Los Angeles, Woodland Hills, Santa Ana, Riverside, and Santa Barbara. Now, what do you actually need to turn in when you're filing your bankruptcy paperwork? You're going to need a copy of your paperwork, the petition and all those schedules, and a copy of that for yourself. You're going to need the credit counseling certificate, which you've already done, copies of your pay stubs for the last 60 days, and make sure to mark out any identifying information like your social security number. And in fact, anywhere where it asks for account information, social security information, you should block out all but the last 4 digits. You're going to need a mailing list. You're going to have a typed mailing list of all of your creditors, and in fact, anyone who appears in the different schedules in the bankruptcy, so co-debtors, things like that, you're going to want to have a typed list of all those people. Now, one thing, the bankruptcy paperwork, you can actually handwrite all of it except for the mailing list. The mailing list is the one thing that needs to actually be typed. In fact, if you try to turn in your paperwork without a typed mailing list, they'll send you back, and in some cases, they'll have a typewriter there and make you type out your mailing list. And the reason that has to be typed is because they scan that in, and they have optical character recognition so they can see who they need to send notification to. So that's, again, the only part of the paperwork that needs to actually be typed is the mailing list. Everything else can be handwritten as long as you write it legibly. There is also a filing fee. Currently, the filing fee is $306, and you should get a money order, cashier's check, or exact change in cash. If you're going to get a money order, we recommend getting a money order from the U.S. Post Office. They will not accept money orders from other places, so I recommend going to the post office, or you can get a cashier's check from your bank, or again, exact change in cash. Now, some of you may qualify for a fee waiver where you don't have to pay the filing fee if you make below a certain amount of income. That's 150% of the poverty line. And if you fail to pay the fee, then your case may be dismissed. All right, so now you've filed your paperwork. What do you need to do after filing the paperwork? There's one meeting in person that's called the 341A hearing. That's named after the section of the bankruptcy code that calls for this. It's also called the meeting of creditors. This is a meeting with the trustee. This is usually 30 to 40 days after you file your case. At the time of filing, you'll get a sheet of paper that has the time, date, and location of your 341A meeting. You must attend this meeting. If for whatever reason you can't make that meeting, if you get sick, you should contact the trustee ahead of time, let them know you're not going to be able to be there. And in most cases, they will postpone one time. Beyond that, and they likely will dismiss your case. As I said, you'll also find out the name of your Chapter 7 trustee. These are randomly assigned based on the time you file your case. You also will need, as I said before, you will need to mail a copy of your most recently filed taxes to the trustee at the address provided in the paperwork. And you should send that tax return via certified return receipt mail. Also make a copy of that tax return so you can bring it with you to the meeting with the trustee in case for some reason they don't receive that. As I've said before, you also need to complete the financial management course after you file. You can do it from sometimes the same provider that did the credit counseling course, but you need to do that. There's a deadline. If you pass that deadline, they will close your case without a discharge. And again, you'll have to pay $260 to reopen your case. So I recommend that you complete the financial management course and take it to the court within, just immediately after filing your case. And there's also a cover sheet that goes with the financial management certificate. It's called Form B23. Usually, when you do the financial management course, they will email you a PDF of your certificate along with a copy of Form B23. You need to turn in both of those. If you fail to turn in either of those, some people we've seen where they turn in the certificate, but they forget to turn in Form B23, their case still gets closed without a discharge. They have to pay $260 to reopen it. As I said, with this financial management certificate, you do not mail the financial management certificate to the trustee. You're going to take it in person to the bankruptcy court along with the cover sheet, which is Form B23. Just to reiterate, if you don't file the financial management course, your case will be closed without a discharge, and you'll have to pay $260 to reopen your case. I'm going to talk a little bit now about the meeting with the trustee, which is the meeting of creditors, the 341A meeting. It has a lot of different names. This is what you need to bring to that 341A meeting. You need a copy of your Social Security card. Again, if you don't have your Social Security card, you can go to the Social Security Administration and they'll provide you a copy of that, although that can take a couple weeks, so you should look right away, and if you don't have a copy, you should order that right now. You'll need a valid driver's license or some other government-issued ID, a copy of your petition, a copy of your most recently filed taxes. These are the taxes that you've already mailed to the trustee. And also bring a notepad and pen in case the trustee needs additional information. You can write down what the trustee needs, or if the trustee is going to continue or postpone your meeting to a different date, you need to write that information down. So at the hearing, you should plan to arrive 30 minutes before your hearing starts. And this is because sometimes you might have issues with parking, but also you want to see some of these meetings ahead of time. The layout of the meeting, in most cases, it's going to be in a big room where there'll be rows of chairs. The trustee will be in the front with the trustee's assistant. They'll call people up, usually one at a time, swear them in, and they'll ask a series of standard questions. Some of those questions include, did you read everything before you signed it? Did you sign the paperwork? Do you have any additions? Do you have any changes? Did you list all your debts? Did you list everything you own? So you'll see, if you get there early, you can see by watching other people's meetings the kinds of questions they ask. And in most cases, it's standard questions. And in most cases, if you've done your paperwork correctly, this should be a very short meeting. In a lot of cases, it lasts shorter than 90 seconds. So it should be a very short meeting. It can go longer if the trustee needs additional information. There will also be, when you arrive at the meeting, you'll see a stack of green pamphlets. You want to pick up a copy of the green pamphlet and read the pamphlet, because the trustee will ask, did you read the green pamphlet? There's also, in many cases, if you're representing yourself, there'll be a separate sheet of paper for people that are representing themselves. So you need to pick that sheet of paper up too, because the trustee will ask about that. The trustee will swear you in under oath, under penalty of perjury, and it is your responsibility to testify truthfully. So even though this isn't in a court, you are testifying under penalty of perjury when you are answering the trustee's questions. Now, after the meeting, you may need to do the following. The Chapter 7 trustee may request additional information from you. What you should do is send that information via certified mail and with a return receipt. That's where you attach the postcard, and they'll send you a postcard back once they've received the mail. It costs a little extra, but it's worth it just to make sure that they've gotten the information. Sometimes the trustee will ask you to amend your schedule. So if there's something you didn't include, you forgot to include in there, there's a certain debt you forgot to include or assets you didn't include, the trustee may ask you to amend those schedules. And if you need help with that, you can come to the self-help desk, and we'll give you all the forms you need to be able to amend your schedules and then submit those to the court. You need to attend any continued hearing date. So if the trustee has said you need to come back on such and such date, you need to make sure to come back on that date. Now, sometimes the trustee will say, all right, I need this information, and if you get this information to me before the continued hearing, then you don't have to come in. So sometimes if you get that information, you'll be excused from coming in that second time. But in order to confirm that, you should call the trustee's office and get confirmation via mail that once you provided that information, you don't have to come back. And again, your case may be dismissed for failing to cooperate with the Chapter 7 trustee. All right, now let's talk about discharge. This is what all of you want in your bankruptcy case. A discharge is what eliminates all of your unsecured debts, or at least the debts that can be discharged. If you don't receive your discharge within 4 to 6 months of your hearing, you can contact the court to see what's happening. There may have been some error. Usually, the discharge will occur within about 2 to 3 months after your meeting with the Chapter 7 trustee. If you change your address, you need to let the court know. There is a change of address form, which is on the court's website, or you can come to the self-help desk and you can file that change of address. Otherwise, you're not going to get a copy of your discharge in the mail, and you won't know that you've received your discharge. So if at any point you change your address, you need to file a change of address form. When you get your copy of the discharge, hold on to that. File that. This is something you want to hold on to, make copies of it. This is your proof that those debts have been discharged.